The judicial arm of government is regarded as the last hope of the common man. But what happens when it is not independent enough to perform its role? This has been the concern of many about the Nigerian judiciary over the years, as it receives its operational funds from the executive arm of government, threatening its deserved independence. But a bill granting this all-important arm of government financial autonomy at a state level has been signed into law by President Muhammadu Buhari. This seems to be a good piece of news, but what does it really mean for the judiciary? Indeed, what is the judiciary and what are its core duties?
Well, the Nigerian judiciary is essentially an institution charged with the interpretation of the law of Nigeria generally, and particularly in terms of the resolution of conflict among the different individuals and organs of government. And of course, it's not so much about judges as we often misconstrue it. It's not judges alone that makes up the Nigerian judiciary. Of course, there are also non-judicial staff. At times, if you want to stretch the word further, you can even extend it as far as other stakeholders like the lawyers, members of the Nigerian Bar Association that also in one form or the other, as well as the prosecutors of the various courts that oils the machinery of justice.
Is constantly provided for under Section 6 of the Constitution of the Federal Republic of Nigeria to administer justice to all and sundries in Nigeria.
It must be noted that states also have their own judiciary. The Nigerian judiciary has 8 major courts. They are the Supreme Court, the highest in the land, the Court of Appeal, the Federal High Court, the State High Court, the National Industrial Court, the Sharia Court of Appeal, the Customary Court of Appeal, and the Magistrate and District Courts. Like other arms of government, the Nigerian judiciary also has a history dating back to the colonial era. After 1960, when Nigeria gained independence from Britain, its colonial masters, the judiciary began to show promise that it could stand on its own.
Before they came, there was a semblance of method of dispute resolution. Among the Igbos, recourse is made to the family head, and if the issue is not being resolved, recourse will be made to the head of the compound. And so when this existed among the Igbos and also the Yorubas of the western part of the country. But however, in the north, because the north was predominantly an Islamic region, so the Islamic clause that the Sharia law has incorporated within it a system of administration of justice and dispute resolution under the Sharia law. So they had a more of a formalized system. They had the alkali, who are the judges, and also they had the emirs, who sit on appeals over decisions of the alkali judges. And then in the southern part of the country, they had to establish what we called the courts of equity. And these courts of equity were styled, they are styled like English type of courts. But however, in spite of creating these courts of equity, they still preserve the customary courts. Between 1842 and 1912, there has been substantial improvements in how the judiciary was ordered both in the north and the southern part of the country. So these courts continue to coexist side by side until the Southern Protectorate and the Lagos Colony became one full protectorate. So they had a Supreme Court, and also they had the Customary Court and the Native Court. Appeals from the Customary Court goes to the High Court, and appeals from the High Court goes then further to the Supreme Court. And then in 1914, there was an amalgamation of the northern and the southern protectorates of the country. When this happened, then there was a fusion of these two systems. So at this point, we had what we call the West African Court of Appeal and also the Privy Council. So what you have was that in the southern region of the country, when there was an appeal against the decision of the Supreme Court, it goes to the what used to be known as the West African Court of Appeal, and then from there it goes on to the Privy Council. This was the practice until sometime in early 1950s. We now abolished, at that point, there was now a federal Supreme Court, which was established in Nigeria. So this federal Supreme Court was now headed by a Chief Justice of Nigeria. And so at this point, of course, the country was gradually working towards independence. So the West African, the Privy Council had to give way.
Nigeria is regarded as the giant of Africa, rich in human and natural resources. But these have not shielded it from having challenges that impede its progress and development. Its judiciary is definitely not immune from some of these challenges plaguing the country. This arm of government has been fighting several battles over the years. From lack of infrastructure to corruption to inadequate funding, the problems seem endless.
There is the issue of the infrastructure. To a large extent, in virtually all courts that we have in Nigeria today, we have infrastructural collapse. And what we have there is totally inadequate and not modern to cope with the challenges of the judiciary. Secondly, is the aspect of the welfare of those people responsible for the adjudication. Today, they are poorly paid. In fact, I reckon that they probably will be the poorest paid in the country today, because they are the Nigerian judges and justices are the only ones since 2008 that have not received a single increment over and above what they've been paid since 2010. Of course, you know what the inflation rate is today, when it was there, what the exchange rate was then, what the exchange rate is today. And inflation, a lot of issues, even the value of goods and services in the country.
These two issues tend to fuse and then make the practice of law at times convoluted and sometimes even fail in its primary mandate of delivering justice to people. So let me put this in context. Speaking of the structure, so we have just one Supreme Court of Nigeria servicing the entire 30 states of the Federation and the Federal Capital Territory. So you can imagine the sheer load of work that the Supreme Court will have to be involved in. So this automatically makes cases to take a long time before they reach a determination to finality.
Lack of adequate funding, and of course that ties to the fact that the infrastructure is not up to standard, and that's because of funding. So basically the underlying problem would be that of funding.
The delay in the administration of justice generally. And by the delay, we're talking about the length of time that it takes to institute, adjudicate, and finally determine an otherwise simple matter.
Corruption is a serious problem in the country, but lawyers differ on the matter of corruption as it concerns the judiciary.
You see, the problem is that, again, we have not ensured the independence of the judiciary. The executive dabble largely into the affairs of the judiciary, and that is why we are having the issue. Once we are able to insulate the judiciary from the interference of the executive, then we are cool and dandy. But right now, because, like, particularly in terms of financial independence, they are, like I said, the judiciary anyhow. And even if at the end of the day there is an element of corruption or irregularity or impropriety, so to say, we have the National Judicial Council. Maybe the best that we need to do is to overhaul that council in terms of its membership to make it more potent.
When you have allegations of corruption within judiciary, the heads of courts are custodians of that institution. So there is no way that those allegations will not rub negatively on the heads of court. And unfortunately, a lot of those allegations have come out to be more accurate than inaccurate. So yes, the Supreme Court is under fire. The heads of courts, in other jurisdictions have also come under great attack. So it just shows that in the legal profession and the justice system as a whole, that we need to pay more attention to the kind of lawyers we appoint into the bench.
Incidences of corruption. I need to put a caveat here. There's no point or no use playing the ostrich. However, I can, as a practitioner, attest to the fact that most Nigerian judges are upright. Most. In short, not just upright, industrious, hardworking, diligent, and guided by the principles of fairness and justice and equity. To be frank and to be charitable to them, most of them overwork themselves, overreach themselves, just so that that temple of justice is not desecrated, just so that things are done right and the society is properly organized and better off for it.
This concept of separation of powers means that the judiciary should not depend on other arms of government, financially or otherwise. Many Nigerians and groups had clamored for financial autonomy for the state judiciary over the years. One of such groups is the Judicial Staff Union of Nigeria, Judicial, an affiliate of the Nigerian Labour Congress, NLC.
Even we at union level, we are working assiduously day and night to ensure, because our position is this issue of financial autonomy and independence is non-negotiable. It's a pipe to finish.
The call reached a peak when members of Judicial embarked on a strike on the 6th of April 2021 to press home the demand for financial autonomy for the judiciary. The strike lasted 64 days, the longest industrial action in the history of the judiciary in the country. It should be noted that the judicial workers embarked on a similar strike in 2015, which lasted 2 weeks.
Last strike was suspended in 2021, in which in the course of this I had this accident, which I have 6 fractures. God be the glory, I'm alive, I'm granting interview now. But none of the state actors in this MOU we reached to suspend that strike for 2 years has implemented. None. And we have written several reminder and call. We met, we decided we wanted even to embark on industrial actions. We look at it, it's just a mere coincidence. The moment you did it, they will give it a political meaning. But it's 2 years. They didn't comply. They didn't implement with that MOU that lead us to suspension of the strike. And it's not that we have slept over it. We have been engaging them, reacting to them. There's no response from one technique to another until one we find ourselves where we are today. But that's no problem. We will manage.
In May 2020, President Muhammadu Buhari signed an executive order granting financial autonomy to the legislature and the judiciary of the 36 states of Nigeria. This was short-lived as the Supreme Court nullified the order in February 2022, stating that the president overstepped his constitutional powers by signing such an order.
That order, in effect, was more or less a directive to the Accountant General of the Federation to ensure that in event of releases, financial releases, appropriations to agencies of government, in particular the legislature and the judiciary, the funds meant for these bodies, these arms of government, were to be deducted at source. The whole idea was to guarantee that they received their money in good time, without stress, and for the purpose that it was meant for. I mean, no one could fault that in terms of intention and the purpose and the motive.
The issue of financial autonomy for the judiciary would not die, however, as the Senate on the 1st of March 2023 approved it for the state judiciary, legislature, and local governments in the country. This was after the bill passed second reading at the House of Representatives on the 28th of July 2020. It was transmitted to the President in January 2023 for assent, and the President dutifully signed it into law in March 2023. This seems to be a beginning for restructuring of the Nigerian judiciary. Key players in the Nigerian judiciary noted that it is a right step that will make the legal profession better.
Well, it's going to be of great benefit to all Nigerians. Then we have what is called a judiciary, properly so called. In other words, a judiciary we can all be proud of, confident, and justice will now start reigning in the country. Today, we see a lot of lawyers, not even litigants now. Once the matter is against the state government in the state, they are doubtful of the outcome already.
This has been a battle that has taken long. It's been a long journey to get to the point where our states, not just our states, but also the federal judiciary will be financially independent. And I think it's a step in the right direction that finally we've gotten to this mark where our states have been granted that autonomy by constitutional amendment. And I think it's a worthy step that has been taken, and the president must be commended for taking this step.
Part of true federalism is to have autonomy over a number of things at the state level. And I think this newly signed law will provide exactly that, will enable the judiciary at the state level to function autonomously and to be able to advocate and advance their own brand of how they want to ensure the speedy, efficient, and fair dispensation of justice.
The problem now is how to implement this new arrangement. If you're saying that the states should go directly to the federal government to collect their monies, the problem is how much are they collecting? Is it the same amount across board, or is it according to the needs of each specific state? So there are many questions to be asked. One thing is to make the law. Another thing is how that law will be implemented. And I think that is the greatest challenge we are yet to see.
Some lawyers in Lagos and Abuja expressed satisfaction with the new law, but worry about its implementation.
If the judiciary will be able to do what they ought to do and mete out justice, then it should have some measure of independence and not be compromised by the other arms of government. So sure, it's a step in the right direction. I guess when we see the entire letters of the bill, we can be sure to the extent to which autonomy was granted them.
If you now give them financial autonomy, it will come back. They will definitely come back, because it can't go well. In the sense that, a lot of loopholes will, So I know what I'm talking about, and I believe he knows what he's doing.
As a matter of fact, it's even coming too late. I know that the judiciary has been making that agitation. Surprisingly, it's only the judiciary that is not having financial independence.
Though I have not seen the bill, I have not go through it. It is when I go through it before we'll be able to say, okay, it will come to stay. But as at now, I've only heard about the bill, I have not gone through it. But it will help the society if the judiciary is independent.
Whichever way judgment goes now, its funds will not be stultified by anybody's whims and caprices. That's the advantage of this bill. And we just hope also that the heads of court, who now are in control of these funds, will administer it judiciously for the entire operation of the judicial system from top to bottom.
The new law granting financial autonomy to the judiciary is a welcome development to players in the temple of justice and other stakeholders. They would like to see strict adherence to the rule of law. Stakeholders expressed different opinions about how the new law should be implemented.
In the first place, it's paid to the head of court, but who is accounting officer? It was the chief registrar. And I am of the view, I am of the notion that yes, we are going to be more careful because of the institutions were serving. And I don't think, I'm not ruling out totally 100%, but I'm optimistic. 80 to even 90%, our judicial officers will be extra careful.
One thing we must go back to think about is, and think how it can happen and happen well, is from the constitutional amendment, the monies would have to go to the National Judicial Council, who would now send it to the various heads of courts in the various states and all of that. The process of implementation is very, very critical. We must separate the administration of justice and the running of the court system. You don't want a situation where the judge is being dragged up and down by ICPC, EFCC for misappropriation of funds. So we need to ensure that we insulate the heads of courts, particularly from the disbursement and accounting of these funds.
This is not a novel step towards independence of the judiciary, as constitutional evidence suggests that a pre-existing law granted the arm of government independence, but this has not been adhered to by those in power.
There is nothing new. The signing of that bill only, to my mind, to my view, is going to give a strength more only to some political consideration, because there's nothing new as far as judiciary is concerned, apart from some fundamental two soft provisions within the Constitution. Judicial went to court seeking for the interpretation of Section 121 sub 3, Section 81 sub 3, and Section 162 sub 9. And all these of the 1999 Constitution as amended. And all these constitutional provisions dealt with the issue of financial autonomy and independence of judiciary. Our praise is for court to interpret whether the manner and the approach adopted by the executive arms of government in terms of implementing or compliance to those provisions are in accordance with what the Constitution says.
Legal experts noted that this should not be the last step, but that other bills, laws and reforms that would engender improvements in the sector should be passed.
I think that the National Judicial Council is dealing with so much. And I'll give an example. National Judicial Council sits in Abuja and regulates how many judges Lagos would have to have, for instance, and how many judges that Gombe State would have to have and Bayelsa State. I think that there should be a way that we have better federalism, where Lagos, for instance, is able to speak to its need and attend to its need. So I see a situation where there's more autonomy given to the states for appointments and discipline of judges.
We have called for a different recruitment system. At the moment, it's a ritual. When I say it's a ritual, what I mean by that is that it's just a pattern that recognizes, for instance, seniority. It must be so with or without the competence and expertise and discipline and character and knowledge that is required. So if you are the oldest serving judicial officer, you are automatically to succeed the retiring head of the judicial system in the state where you find yourself.
In the 8-year tenure of President Buhari, a total of 21 constitutional alterations were made. The incoming government has been asked to take necessary steps to reform the judiciary. The importance of the judiciary cannot be overemphasized. Every year, hundreds of thousands of Nigerians approach the temple of justice to seek one form of redress or another. It is expected that autonomy for the judiciary would make it more incorruptible and reinforce its reputation as a last hope of the ordinary man.